Good afternoon, everyone. My name is Kristen Warner. I'm an associate attorney in Bond's Rochester office. I do some municipality work, general municipal work, but for the most part, I concentrate on school district work. Today, I'm going to be doing an overview of the Freedom of Information Act, otherwise known as FOIL, and how best to deal with FOIL requests. So what is FOIL? FOIL requires governmental agencies, including all kinds of municipalities, villages, towns, cities, public libraries, school districts, to enact rules and regulations governing the availability of records, to make certain records, and to make all records available for public inspection and copying, except those specifically defined in statutory exceptions. FOIL can be found in the New York Public Officers Law sections 84 through 90. What I'm going to be talking about today is specific to New York State's FOIL law. There also is a federal Freedom of Information Act. Some of the exceptions and provisions are a bit different. So everything today is just about the New York State version. So for policy and rules, every agency, and I'm going to use the term agency to just cover all of the entities that are covered by FOIL today, whether it be a school district, a village, a town, a city, or any sort of administrative agency they're under, police departments, fire departments, those types of things. So each agency must have written rules and regulations pertaining to the availability of records, including but not limited to the times and places records are available, which are usually business hours, and at the main office or district office, wherever the records access officer is located. The persons from whom records may be obtained. So each agency has to name a records access officer, and that's who people should direct their FOIL requests to. And the fees for copies of records. Statutorily, you can charge up to 25 cents per page for copies of records. Records have to be available for inspection and copying at all reasonable times. Like I said, during business hours, when you are regularly open for business. So whether that's 8 to 4, 8 to 5, 9 to 4, whatever your regular business hours are. Any member of the public can inspect or obtain copies of the records. They don't have to be a resident of your town or your city or your village or a school district resident. Anybody from anywhere can make a request. And they also have the right to inspect the records at no charge. So that doesn't involve copying. That just means that they can come in and take a look at the records that you've deemed responsive to their request. However, where there are situations where some aspects of a record, but not the entire record, may be properly withheld, AKA if parts of it have to be redacted, you can prepare a redacted copy and charge them the fee for the copy that is 25 cents per page. And that's for just physical records, that's not for electronic records. So what are records? Under FOIL, a record is defined as any information kept, held, filed, produced, or reproduced by, with, or for an agency or the state legislature in any physical form whatsoever. So basically that covers pretty much all of your paper and all of your electronic messages, emails, text messages, letters, personnel records, contracts, vendor data, billing invoices, copies of checks, voter rolls, minutes of public meetings, recordings of public meetings. FOIL is very, very broadly under FOIL, records are very, very broadly defined and pretty much cover nearly everything that's kept by an agency. Okay, so what are records? Are emails from a public official's personal emails discoverable under FOIL? Yes, they are. They do not have to have a .gov or a .edu, or they do not have to be the official email associated with their office. Are text messages sent between public officials' personal cell phones discoverable under FOIL? Generally speaking, yes, they are. However, there are advisory opinions that stand for the proposition that if text messages have been deleted from the actual device and are only stored with the service provider, say T-Mobile or AT&T, then you would not be required to produce them, as that service provider is a private entity and therefore not subject to FOIL, and they cannot be compelled to cooperate. But the New York State Committee on Open Government has specifically stated that electronic communications such as emails or text messages, so long as they involve government business, whether stored on a governmental or personal device, constitute records that fall within the coverage of FOIL. So if you're just chatting with another board member about your kid's baseball game, that wouldn't be considered a record that would fall under FOIL. But if you're talking about, how you're going to vote on something at your next board meeting, that would fall under the definition of a record. There are also certain records that have to be maintained by statute. So a record of the final vote of each member in every proceeding in which the member votes. So anytime anything is voted on in a board meeting or a board of trustees meeting, those votes have to be recorded and those have to be maintained by statute. You also are supposed to have a record that has the name, public office, address, title, and salary of every officer or employee of the entity. Under FOIL, public employees and officers have much less privacy than private citizens do. And that's why a lot of this information is available to the public when you work for the government. You're also supposed to maintain a reasonably detailed list by subject matter of all the records that are in the possession of the entity, whether or not available under FOIL. And you're supposed to update that annually. That's one that a lot of entities don't realize that they're supposed to maintain. I have had requests where people have asked to see the list, and it's like, oh, we don't keep that. So yeah, that's something that you should make sure you have. And it doesn't have to be like specific to each kind of record. Generally speaking, personnel records, payroll records, those types of generic titles are sufficient for this kind of list. So there are records when you have to make them available, except those that are specifically allowed to be withheld under New York State Public Officers Law, Section 87, paragraph 2. That's where all of the exceptions are housed. So records that may be withheld. So if somebody makes a request, these are the ones that you can say, no, we're not going to give these to you. There are those that are exempt by a state or federal statute, such as FERPA for student records. FERPA allows that federal funding can be withheld from an entity that discloses personal information under FERPA that it's not supposed to. Also under New York State law, attorney-client communications are protected. So people cannot ask for, attorney work product or advice given over email between a board and its attorney. Certain things may be withheld because disclosure would be considered an unwarranted invasion of personal privacy. There are also issues with records that would cause an impairment of present or imminent contract awards or collective bargaining negotiations. Those come into play when you are in the midst of collective bargaining, or if, say, an RFP has been issued but not yet awarded. Somebody that's trying to respond to an RFP cannot request the documents, the bid that another company has already put in, but it hasn't been awarded yet, because that would allow them to undercut their bidding. Trade secrets or records information from commercial enterprise, which if disclosed would cause substantial injury to the competitive position of the enterprise. That one comes into play again with RFPs sometimes after the bid has been awarded. You'll get requests from the losing bidder sometimes to get all of the documents, and sometimes within the bid packages that are submitted themselves, there's certain financial information or trade secrets that are so secret that they can't be disclosed without basically making it impossible for them to continue in that line of business. That's one that's that comes up not very often. Other records that may be withheld are records that are compiled for law enforcement purposes, and which, if disclosed, would do one of the following: interfere with law enforcement investigations or judicial proceedings, deprive a person of a right to a fair trial or impartial adjudication, identify a confidential source or disclose confidential information relating to a criminal investigation, or reveal criminal investigative techniques or procedures except routine techniques and procedures, or that would endanger the life or safety of any person. This one comes up quite often. There is some new case law, relatively new case law on this too. In 2022, a First Department case made clear that the law enforcement exception also applies to civil internal investigations, as well as those outsourced to third parties such as a law firm. So if you have a sexual harassment complaint and you hire a law firm to come in and investigate that, certain materials might be withheld while the investigation is ongoing, even though it's not being done by a police investigation. There is one caveat with invoking this exception as well. Recently, the law changed to require that any agency which is not conducting the investigation themselves cannot invoke this exception without first checking with the group that is doing the investigation and making sure that such disclosure would interfere. So if, say, a school district had an issue on campus and the local police department is the one conducting the criminal investigation, if the school district wanted to withhold records under this exception, they would first have to go to the police department and have them confirm that such disclosure would interfere with the investigation. But if your entity is the one doing the investigation yourself, that's a step you do not have to take. Some other records that may be withheld are InterAgency and IntraAgency materials. Of course, there's an exception to this exception, so that you cannot withhold records under this exception if they contain statistical or factual tabulations or data, instructions to staff that affect the public, final agency policy or determinations, external audits, including but not limited to audits performed by the comptroller and the federal government. This is one that comes up quite a bit. The rationale for this is to promote open communication between agency employees. So if there's, if it's advice or recommendations or, just chatter amongst employees over email, those can generally be withheld as long as they're not final policy determinations and they don't contain like factual allegations. Another one that may seem obvious, but had to be put into the statute is that you cannot request examination questions or answers before the test has been given. And you can also not request computer access codes. Those are things that can be withheld. There are also some specific records that can be exempt from disclosure, such as ADA and FMLA leave-related records. There are some advisory opinions that say that non-final disciplinary records, such as counseling memos, investigation notes, and warnings can be withheld under the intra-agency exception. However, the counseling memos must not contain any disciplinary action or a finding of misconduct. So what could be withheld would be documents that have just opinions, advice, recommendations, and the like. Factual information would be available except to the extent that disclosure would result in an unwarranted invasion of personal privacy. So basically, if the counseling memo is essentially a warning rather than a conclusion reflecting a finding of misconduct, it would not constitute a final agency determination and could be withheld. There is some conflicting case law out there right now as to whether unfounded allegations against somebody have to be disclosed. There's been some troubling case law that says that they do have to be disclosed, even if they are unfounded, but there are other Committee on Open Government advisory opinions that say that unfounded allegations, the name of the person against whom the allegations have been made, if they are unfounded, and any witness names can be withheld on complaints. Other records that can be withheld are medical treatment records. Usually the home address, the home phone number, or the personal email address of employees of a governmental entity. Workers' comp records cannot be disclosed. And then when you have a request for personnel records, parts of resumes that are unrelated to the position for which the public employee was hired, such as your college GPA, your marital status, hobbies, etc. Also, any personal references and their contact information, that stuff can be withheld as well. Some other ones are application materials for unsuccessful job candidates. So, you don't have to disclose somebody's resume if they didn't end up getting the job. And also prohibited from being disclosed under statute are IEPs, individualized education programs for students. So one of the exceptions that most prominently comes up is the unwarranted invasion of personal privacy. So this covers employment, medical or credit histories, or personal references of applicants for employment, medical or personal records of a client or patient in a medical facility, the sale or release of lists of names and addresses, if such lists would be used for solicitation or fundraising purposes, and disclosure of information of a personal nature when disclosure would result in economic or personal hardship to the subject party, and such information is not relevant to the work of the agency requesting or maintaining it. So say you have emails between two employees where one is lamenting, marital issues, that wouldn't be relevant to the work of, it wouldn't be relevant to her job, and therefore that any disclosure like that would be an unwarranted invasion of personal privacy. With regard to the release of lists of names and addresses, when this involves the requester being a political candidate and they're requesting voter roll information with names and addresses of voters, if they're seeking the list just to explain their position on the issues or merely seeking support, it's not considered solicitation and can be released. However, that analysis changes that they're seeking monetary support, then that would fall under the fundraising, and the agency could deny the request on the basis that such disclosure would be an unwarranted invasion of personal privacy. So there's other things fall under this exception as well. So information of a personal nature contained in workers' comp records, except as provided by a certain section of the workers' comp law. Disclosure of electronic contact information, such as the email address for a social network username that has been collected from a taxpayer under Section 104 of the Real Property Tax Law. That deals with electronic property tax administration. So if you sign up to pay your taxes or get copies of your deeds using your personal email address or your social, or like your Facebook name, that can't be disclosed. Disclosure of law enforcement arrest or booking photos of an individual, unless public release of such photographs will serve as a specific law enforcement purpose, and disclosure is not precluded by any state or federal laws. I would also note that you can't invoke the personal privacy exception on behalf of a requester. When it's the requester whose privacy would be invaded, they can provide a copy of their ID and sign a waiver. You would send it along with a letter that states, because the records you have requested pertain to yourself, but if released to the public would constitute an unwarranted invasion of your privacy. As a condition precedent to disclosure, please prepare the following statement on a separate sheet of paper, sign it, and mail it to the address indicated below, along with a copy of your ID. And you would just have them say, I certify that my name is X, that I reside at 123 Main Street, that I have attached a copy of my valid driver's license or equivalent, and that the requested records pertain to myself. So that would be somebody, sorry, that would be somebody looking for a copy of their own personnel record, where certain information you would normally withhold if it was just, Joe Schmo asking for it. But if it's the person whose records they are, they can waive that. So like I said before, the inter and intra-agency exceptions are designed to provide for open internal communications. Intra-agency is amongst your own staff. Inter-agency is when like a police department and a school district are talking, or the city and a town are talking. That's what those would fall under. And like I said before, it does not include those certain things. So there are some common myths about FOIL. So the first one is the draft myth. And that means that just slapping draft on something doesn't make it exempt. It needs to be an actual non-final draft of a record. You can put that watermark on it till your heart's desire, but it doesn't mean it's going to make it exempt from FOIL. The minutes myth, draft minutes are still FOILable because minutes do not need to be approved under the Open Meetings Law. There's no requirement that minutes be approved by the whatever board at their next meeting. So minutes should be available nearly immediately afterwards. The personnel records myth, there's no exception for personnel records contained within FOIL. Sometimes the content can be redacted, but for the most part, those are subject to disclosure. And that's, like I said, because public employees enjoy a lot less privacy than private employees do. And then the confidentiality clause myth. This comes up in the context of settlement and or separation agreements. A lot of times there will be a confidentiality clause in those, but there's case law and advisory opinions that say that just putting that in there does not trump access rights under FOIL. This came up a lot for some of our downstate friends. There were a few news organizations that were requesting all of the separation agreements for all of the governmental entities downstate. And then there was a large article about processes and procedures because they were entitled to see these separation agreements. So procedures for responding to a request. You must respond to a written request for a record reasonably described within 5 business days of receipt of the request. And you can do this one of 3 ways. You can make the record available if it's, say, it's an easy request. You can deny the request in writing if you know that that's not something that your entity is going to disclose, or you can just furnish a written acknowledgement of the receipt of the request and a statement of the approximate date, which is reasonable under the circumstances when the request will be granted or denied, including a statement that access to the record will be determined in accordance with Public Officers Law Section 89.5. So basically you say, we're in receipt of your FOIL request dated, January 1st, 2023. You will have an answer to your request by, usually it's 20 days has been determined as reasonable, though it's not officially, there isn't an official statutory number of days that you have to respond, but 20 days has been held reasonable in the past. Constructive denial, if you don't respond to a request within the 5 business days, or if you delay responding for an unreasonable time after you acknowledge that it's been received, but you don't actually approve or deny the request, it can be considered to have been constructively denied. And constructive denials can be appealed. So, just ignoring it and hoping it goes away is not the best way to deal with FOIL requests. Extensions. If a request cannot be fulfilled within those 20 business days after the date of the acknowledgement, you have to, in writing, state the reason for the inability to grant the request and a date certain within a reasonable period when the request will be granted in whole or in part. And under this one, the reasonable period really depends on what the issue is with the delay. If it turns out that there's 10,000 records that need to be reviewed, it's going to be more than 20 days before you can get through those. So it just has to be a reasonable period for the amount of records requested and the nature of the records requested. And what it will take to provide a response. Voluminous requests. Unfortunately, you cannot deny a request on the basis that the request is voluminous or that locating or reviewing the requested records or providing the requested copies is burdensome. If your agency lacks sufficient staffing, you can engage in outside professional service to provide copying program or other services required to provide the copy. I do a lot of FOIL review. A lot of municipal entities will outsource that to law firms, especially when you have to make fact-specific determinations on whether something qualifies as an intra-agency communication or not. This is an issue where the law has not caught up with technology. In the past, when it was physical records, you could dissuade voluminous requests by charging 25 cents per page. People would balk it, we'll give you the records, but it's going to be, $300. Now, however, if a requester seeks the records electronically and the agency has the ability to produce records that way, you have to. And all you'll be able to charge for is the cost of a flash drive, which is unfortunate. Creating records. There are no obligations to prepare a record that it does not possess or maintain. However, there's some case law that says if portions of a records, say a database, if it's in Excel and it can be extracted or generated from existing records with reasonable effort, you're supposed to do so. Any programming necessary to retrieve a record maintained in a computer storage system and to transfer the record to the medium requested by a person is not deemed to be the preparation or creation of a new record. Something to keep in mind here is that FOIL covers documents, not information. One of the biggest issues that I see with many FOIL requests is that they're posed as requests for information, or they're seeking answers to questions rather than reasonably describing an already existing record. And when that happens, you can deny it. If they're asking for the answer to a question and that's not a record, you can deny that request. Fees. Like I said, you can charge 25 cents per page for a 9x11 photocopy. You can also charge a fee for the medium, like a flash drive. And when you are making physical copies, you can require payment in advance before you have to do it. However, you cannot charge for employee copying, searching, redacting time. The Committee on Open Government has said, based on the language of the statute, it is clear that the only fee that may be charged when a request involves photocopies of paper records up to 9x14 inches is a maximum of 25 cents per copy. No additional fee may be charged for employee time, for search, redactions, etc. And that's where the issue comes in, because it does take up a lot of time, especially when they are sensitive records and there are things that should be redacted in them by statute or regulation, such as, I represent a lot of school districts. So, if somebody's looking for emails between employees, there's a good chance that there's going to be some FERPA protected student information contained within them. And therefore, each record has to be reviewed to see if there needs to be redactions made. And it's a time consuming effort. And unfortunately, you're not allowed to charge for that. Employee time may be charged only when the request involves other records, those that are larger by 9x14 inches or which are maintained electronically. And even then, it's only in circumstances in which at least 2 hours of employee time are needed to prepare the records. The case law and advisory opinions on these deal with things where programs have to be created to cull a database for certain information. It's not, if somebody had to write code to search email, that would count if it took more than 2 hours of time. You could charge for that employee's time. But the provisions concerning the actual cost of preparing copies of records specify that preparing a copy shall not include search time or administrative costs. So that would cover, the pulling, the actual time it takes to go through records and pull the files out, or copying, how long it takes to copy or scan records, or redacting records. Okay, so employee time for electronic records can be charged, like I said, if there's programming involved, but only when at least 2 hours of the employee's time is necessary to prepare it. And then again, if the document exists in electronic format and the agency has the authority and the ability to redact electronically, which most people do now because you can do it in Adobe, you can also do it in a lot of the other PDF softwares. We believe it would be reasonable for the agency to provide the requested redacted copy at no charge in light of the statutory fee provisions. And that is a fairly recent advisory opinion from the Committee on Open Government. With respect to scanning paper records in order to transmit them via email, It is our view that if the agency has the ability to do so, and when doing so will not involve effort additional to an alternative method of responding, it would be required to scan the records. So if you only have records in paper form and somebody wants them electronically, you have to scan them for them. And when emails can be emailed, when materials can be emailed, there would be no fee because those records are not photocopied and a storage medium is not involved. So if it's only, you know, a few records and they're electronic, you don't even need to put them on a flash drive if they can be emailed to the person. Or if there's another, a lot of file share sites can be used in this method that would avoid needing a physical storage medium like a flash drive. So if you're using Google Docs to upload or download the documents, I know our firm uses Kiteworks, which also allows an uploading and downloading file sharing secured system. Then you would not be able to charge for anything under those circumstances. So a FOIL decision can be appealed. Denials can be appealed in writing within 30 days. Appeals go to your agency's head or chief executive. So it will go to, you know, a school district superintendent or a mayor, or it also could be designated as the governing body. So it could go to your board of trustees, your board of education, whoever is designated by the governing body to receive and decide such appeals. Your response has to be made in 10 business days of receipt and must fully explain in writing to the person requesting the records or reasons for further denial of access to the records. So, you know, usually you go into even more detail when the appeal is being decided. Another requirement is when you do deny any part of a FOIL request, in that denial, you have to apprise the requester of their ability to appeal the decision and who they should write to do so. That's required by statute. The response must provide a particularized and specific justification for denying access or a factual basis for claiming an exemption. So just doing a blanket, this is an intra-agency communication, usually isn't good enough. You have to say, like, we have reviewed the materials and certain parts contained within contain non-factual information that are covered by the intra-agency exception. And when you do send the appeal, you have to send a copy of the appeal and the determination to the Committee on Open Government. Judicial appeals. Appeal denials can then be challenged in state Supreme Court via an Article 78 proceeding. The court must award reasonable attorney's fees and other litigation costs against the agency if the person requesting the record substantially prevails and the court finds that the agency had no reasonable basis for denying the request. The law regarding attorney's fees and FOIL proceedings was changed in 2017. Now, where a court finds that the requester substantially prevailed and the agency had no reasonable basis, granting attorney's fees is now compulsory, where they used to be discretionary. That's something to keep in mind when denying a FOIL request. Make sure that you do have a very good basis for denying that request that you can articulate and prove to a court. There could be situations where the requester substantially prevails, but the court finds that there was a reasonable basis for not disclosing the records. But it seems for the most part, if the requesting party wins in court, they're going to be granted attorney's fees. There is another section of the statute, however, that does provide for discretionary attorney's fees, and that's when a court finds that the agency constructively denied it and didn't respond within the statutory provided time frame. And I would be wary of these provisions. There's actually some firms out there that are considered to be FOIL trolls. I know you've probably heard patent trolls before. There are FOIL trolls as well, who just make requests and then appeal them to get attorney's fees. That's their sole basis for existing. So that's something to keep an eye out for as well. And now I'm just going to talk about a few recent cases that have been handed out in the past year related to FOIL, and then I'd be happy to take any questions you might have. So this case in Reuniformed Patrolmen's Association of the Town of Greece is a PERB decision where it was decided that internal pre-disclosure procedures related to the release of police disciplinary files are a mandatory subject of negotiation, and that the town violated the Taylor law by refusing to bargain with the police union over these pre-disclosure procedures. Now, this doesn't deal with the disclosures themselves, because a town cannot bargain away its duties under FOIL. This is based on the idea that the release of documents would impact an officer's privacy and reputation, which is a term and condition of employment. So the ALJ found a safety concern also. What if an officer engages with someone in the community who has received copies of his discipline, but the officer doesn't know that? This could present a heightened risk of confrontation, which affects the officer's employment. So this deals with pre-disclosure procedures, such as should the entity notify a employee that somebody has requested a copy of their records? Should the employee be allowed to review the documents before they're sent out, or comments or have opinions about should there be some discussion about what's redacted and what's not? So those are the things that are required to be bargained over, not the actual disclosures themselves, because that's governed by FOIL. This second department case dealt with a request for various categories of records pertaining to attorneys who have committed misconduct, regardless of whether any consequences were imposed. And the denial was upheld because the request failed to describe the documents sought with sufficient specificity as to permit respondents to identify and locate them. Basically, you can't just say, hey, I want all of these records about this, but there's nothing specific about it. In this case, the records weren't stored in a way that would make that searchable. And they would have to manually review all of their employees' personnel files and make individual determinations as to whether each employee fell under this or not. So they found that denial was appropriate there, because that was too much work for the agency to have to find the documents. Now, if you deny something like this, they can just come back and make another request that's more specific. So that's something to bear in mind too. If you have a good idea of what they're looking for, you can make them ask for it specifically, or you can just, assume that that's what they're asking for and give it to them. Now, there's two cases that came out in 2023 that deal with whether an agency responding to a FOIL request after the requester has filed an Article 78, whether that renders it moot. And they actually came down kind of differently on these. So there's a bit of conflicting case law on this. So this was a very fast moving FOIL, this Suffolk County one. So on July 5th, 2018, there was a FOIL request submitted to the agency's chief clerk, and there was no acknowledgement received. So 11 days later, they submitted a second letter to the chief clerk labeled Notice of Appeal, and again received no response. Then, less than a month later, on August 15th, 2018, they filed an Article 78 seeking the records and attorney's fees. After the Article 78 was filed, the county provided some documents but denied others. The county argued that the requester did not appeal properly and was not sent to the county's FOIL appeals officer. This is important because the court rejected this argument. One of the requirements for filing an Article 78 is that you have exhausted all of your administrative remedies, aka you did the appeal to the actual agency itself before you filed in court. However, if the agency themselves doesn't tell you that you have to appeal to them first, that requirement is waived. Because how can you be held to that when you weren't given notice of it? The county also argued that the litigation was academic because they responded to it after it was filed, The court also rejected this argument because the county only provided certain documents and relied on exemptions for other, and there was a dispute over the exemption. So it wasn't there. There were still disputed facts there, so that they said it wasn't completely academic. But then this other case in the first department, the city reviewed and responded to the FOIL request after the Article 78 was filed, and the court found that the city's response rendered the proceeding moot. Petitioner did not amend the petition to challenge later determination of the request, and the validity of respondents' claimed exemptions were not before the court. So in that case, they were not awarded attorney's fees and were not found to have substantially succeeded. And this one is a City of New York case. This one is just kind of an interesting case. The requesters thought uncompressed, high definition, large size, non-watermark digital images of Kings County Old Town records. And the city provided low resolution images and made high resolution copies of the records publicly available on the website. And the court said that that was just fine. Making records available online via the internet was effectively exceeds any requirements imposed by the Freedom of Information Law. This one also goes to if somebody's requesting minutes of your board meetings and you already post them online, you don't have to give them another copy. You can just point them to the website. And I think that was about everything I had today. We're going to end a little quickly, and I would like to apologize. We were supposed to be joined by Kristen Smith, who is the chair of our municipalities department, but she had an unavoidable conflict, so you were stuck with me today. But if anybody has any questions, please feel free to put them in the chat or in the Q&A. It doesn't look like we have any, so I guess we will finish a little early today.